What about
At the
relief?
very least.
Oh, I was just going to ask, what about relief for Mr. Bowe on remand?
Well, Mr. Bowe might not, there wouldn't be a remand, but Mr. Bowe has already filed multiple applications in the 11th Circuit on his.
But your
He should just
solution.
file another one.
But your solution for the page 12 and 13 of your reply proposal that you make would apply for other petitioners in other circuits, but would not help this petitioner.
On this application, but he could simply file another successive application.
So,
And why wouldn't it suffer the same fate? They've already said they're now certifying to us. They've already said they're not.
No, because the Court of Appeals would say the reason we bumped it before is we thought B1 applied. The Supreme Court has construed 2244.
So a third or fourth successive petition for him would be a second or
he's
third
not, he's not even filed a second application
Thank you.
yet.
So, Mr. Yang, can I just, let's say I agree with you that E is a part of the certification process that is being referenced in H. Can I have you address the more narrow jurisdictional argument, which does focus on the text of E? Your argument seems to suggest that we should not pay attention to the difference between granting and denying something, or denying an authorization and dismissing the entire matter for lack of jurisdiction. And I guess I don't understand that. We have very clear procedural requirements and understandings when a court is doing certain things. And here, the Court of Appeals panel did not grant or deny an authorization.
Well, we disagree with that.
Okay.
The statute says, and this is D, the court shall grant or deny authorization. Shall.
Right.
Those are the only two statutory
What if the
options.
court doesn't do that? Let's say the court, let me give you a hypothetical. All right. Suppose we have a 3-judge panel that doesn't do what Congress has said you're supposed to do with respect.
What does it do?
No, let me finish.
Yeah.
All right. So in my hypothetical, the 3-judge panel doesn't apply any of the relevant statutory criteria when it reviews an authorization request. So you agree here that the H1 and H2 substantive requirements apply. And in my hypothetical, the panel says, we don't care about that. We're just going to rubber stamp all of these applications as deny. All right? So we have a rogue panel not following what the statute says. Now, they've technically denied in that sense, but they certainly haven't followed what the statute says. They haven't granted or denied on the merits. And I guess I'm trying to understand why E would preclude someone from appealing that. It seems to me that E was really just about Congress not wanting the actual substantive determination that a panel properly makes to be appealed. What it was not doing was policing all of the, or precluding an appeal about whether or not the panel had acted procedurally properly under the statute.
Well, there's two responses. One is a textual response, and then I think you're actually getting into a policy response.
No, I'm not, actually.
Well, the textual response is this. It says grant or deny. Literally, a dismissal is a denial of the application, as this court has recognized in Gonzalez. It's denied on the ground that the claim would be dismissed. Now, whether a court is wrong in a denial or wrong in a grant, it can happen both ways.
No,
a
but
grant
we're
or
talking,
denial is not subject to review by this court.
I guess I understand your point. It just seems to me to elide a very key and critical thing that Congress was trying to do here, which is Congress gave this panel particular requirements that it has to apply when making this decision. One could conceive of the finality requirement as being, once the panel has gone through and applied H1 and applied H2 and determined that authorization should be denied, that's the end of it. That's final. That's the work of E. To me, and I think textually, it supports the view that if a panel has not done that, if a panel has not actually made a determination about whether or not this should be granted or denied, and say they have dismissed it for some other reason, it doesn't trigger what E is trying to do. There isn't a finality requirement in the same way. Why would Congress have even put in the substantive criteria if the panel could do whatever it wanted? There still has to be judicial review as to whether or not the panel has acted properly procedurally
The premise,
pursuant to the statute.
that premise does not lead to the conclusion. Of course, Congress wanted the panel to follow the law, but the question is whether Congress determined that there should be certiorari review of claims that the panel erred. The statute
Erred with
doesn't
respect
say,
to what?
But the statute does not say grant or deny on the merits. It says grant or deny, period.
All right.
And a
Thank
dismissal is a denial. Moreover, the structure you have with a 30-day time limit, that time limit cannot depend on the disposition of a court, which is unknown in advance. If the court doesn't know if it's going to dismiss or deny, it can't operate under a 30-day time limit unless it knows what the time limit is in advance. That theory of dismissal being distinguishable from denial would apply not only to E, it would apply to D, which is where the 30-day time limit is. It makes absolutely no sense. It's arbitrary, and it would also be asymmetric. It would allow where denials on a non-merits ground, that could go up on cert, but if granted, like if the court rejects a non-merits ground and allows it to go forward, that couldn't be. Again, that doesn't make great sense, and it's not compelled by the text. I think we were talking about certified questions briefly. I just want to address this because I think this is important. The Court of Appeals said that certified questions are very rare, and that's right, normally. But that's because certiorari jurisdiction is available. The standard is when it's advisable in the proper administration and expedition of judicial business. When there's cert, which can be granted before or after judgment, extraordinarily rare. But if cert's not available, and there's a square and significant conflict that's recurring, it's entirely appropriate for a Court of Appeals panel, and you only need 2 judges on a panel, to certify the question to this court, and then this court could decide what to do. Moreover, there's merits review. As you may remember, Justice Kavanaugh, you wrote separately in a case called Avery. Avery came out of the Sixth Circuit raising this exact B1 issue, but it came in a different posture. It came where the panel, certified a second or successive. It went down to district court, was litigated, and came back. The issue can come back on the merits in that way, too. And, of course, there's All Writs Act jurisdiction. All writs is not precluded. Now, it would only address clearest errors.